Now, again, I don't feel that at this juncture, at this point in time, Mr. Rittenhouse has significant ties to Kenosha County. And as such, I believe that there's a reasonable basis to believe that a very significant cash bond is necessary to assure this defendant's appearance in court, as court does believe that he is a flight risk, based upon the comments I just made. And in addition, the case, as Mr. Richards has brought up, he did surrender himself to Illinois authorities, but circumstances appeared to have changed at some point following that with respect to the extradition issues. Court, as I said a minute ago, does believe that for the reasons stated, Mr. Rittenhouse is a flight risk. As such, court is going to impose a $2 million cash bond, believing that is reasonable and necessary and sufficient at this juncture to secure the appearance of Mr. Rittenhouse.
All right. Interesting that the judge was mentioning the extradition hearing as a reason that he might be a flight risk. Very interesting issue there. But let's bring in part of our team of legal journalists here at Court TV, best in the business. Court TV legal correspondent Chanley Painter's with us, and Court TV anchor Michael Ayala. All right, Chanley, I know you were following this closely today. Break it down. What happened?
Well, the hearing was quite contentious and emotional. It was a video hearing, like you said, and the Kenosha County Commissioner spent about 20 minutes hearing from the prosecutor, hearing from the defense, and two representatives of the three victims in this case, including the man that prosecutors say Rittenhouse shot in the arm and survived, 22-year-old Gage Grosskreutz. He appeared there with his attorney to this Zoom call. He didn't say anything, but his attorney spoke on his behalf. But Vinny, the person who stole the spotlight was one of the fathers of the victims in this case, John Huber. He made a poignant plea to the commissioner. Let's listen.
I would like to say that, this Kyle guy is a flight risk. He's facing long time in prison. And he has people out there that will help him, organizations of militia members that are raising money for his defense right now. They can harbor him. He can
I'm going to object to this. There's no basis in fact.
Mr. Richards, that's Mr. Huber's opinion. He may state his opinion pursuant to the current status of the law in Wisconsin. I'm going to allow him to state that position.
Yeah. Kyle Rittenhouse thinks he's above the law. He's been treated as such by law enforcement. And so he believes he's justified in this case, and for him to run wouldn't surprise me. And this defense of self-defense, that is impossible. That is impossible. I don't know what part of the video you watched, but he already killed a guy, shot him in the head, and then tried to run. And my son was a hero. He tried to stop him, and so did everybody else. He was an active shooter, and he tried to flee. And my son lost his life protecting other people. He was a hero. And anyone who says otherwise is dead wrong, including the president, for to comment on that. How dare he? He needs to just stay on Twitter. I'm for doubling his bond. It should be $4 or $10 million, because there's people out there raising money right now, making it their own fight, that it's about gun rights, and it's not about gun rights. My son was killed. Another man was killed. They didn't deserve to be killed, and that guy was unarmed. And my son was unarmed. He hit him in the shoulder with a skateboard. He was a hero.
Huber goes on to say that the people who bought Rittenhouse, a minor, the assault rifle should also be held responsible in his son's death. In fact, John Huber was quite emotional throughout the video hearing today. At one point, he wiped tears away in his eyes through his mask, and very active throughout the entire 20-minute hearing, Vinny.
Yeah, absolutely emotional. I mean, he's talking about his son. I mean, this is a dad who lost his son. Michael, what about the person who purchased the weapon here and provided the gun to Kyle Rittenhouse?
This is one of those things that I've been sort of thinking about as this case has progressed. Why that person hasn't been charged, Vinny. As I dug into the statute regarding minors with guns, there is a section of that statute that clearly says if you provide a gun to a person under the age of 18, you are liable for a Class I felony. Now, that Class I felony is a $10,000 fine, as well as up to 3 years in prison. Now, if that minor takes that weapon and commits a crime, hurts someone, or kills someone, it goes to a Class H felony, which then is $10,000 and up to 6 years in prison. The person who has provided the gun, he lives in Wisconsin, has already said that that's what he did. He bought this gun for Kyle, kept it, and then gave it to him when they went out to Kenosha. So I don't understand why that person hasn't been brought in and charged, because that father raised some great points. Not only that, but he raised the point of the responsibility of the police in this situation. They came and they sort of acquiesced in these acts, which really was like pouring gasoline on a fire. They should have told those guys with those guns to disperse, go away at the very least. They should have at least checked the ID of Kyle Rittenhouse. He looks like a young guy, right? But instead they were busy giving them waters and saying thank you. So he raises a lot of great points, Vinny.
You don't think there'll be a problem checking IDs first? I mean, you have to have some level of reasonable, articulable suspicion, right?
My reasonable suspicion comes from the fact that you look like you're 15 years old. You're a young boy with an AK-47 wrapped around your shoulder.
AR-15.
AR-15, I'm sorry.
Big difference.
Big difference, you're right. Wrapped around his shoulder, but yet and still. The age look, the way he looks, I mean, we've said it many times, he looks like a young boy. Check the ID, right? There's just, again, he's making great points, I think. And he is a father, and he has certainly a real emotional stake in this case, but he did make some great points.
All right, Chanley, let's talk about this. It's a $2 million bond. You know, you're talking about the death of two people, so probably not outrageous. There were some circumstances you might not get any bond. What did they argue, the prosecution here?
Well, the prosecutor, Tom Binger, he asked for the $2 million bond to preserve what the arrest warrant noted as the bond. And he made arguments that, look, this is the maximum penalty for intentional homicide is life in prison. And that would give anyone reason to be to run or to be a flight risk. Let's listen to his argument.
There were multiple hearings in Lake County as recently as Friday, in which the defense had filed numerous motions and arguments challenging this case and challenging Wisconsin's right to extradite the defendant. I take that all to mean that the defendant doesn't want to be here and, if released, won't come back. So I think that that is something the court should consider very seriously. The defense will suggest that the defendant turned himself in on the night of this incident and therefore is not a flight risk. I would suggest to the court that the circumstances have changed substantially since the defendant did that. At that time, perhaps he had the mindset that he was justified in what he was doing, that the police would hear his explanation, give him a pat on the back, and send him out the door. Clearly, that's not what happened. Clearly, he's facing serious charges in this case. And whatever his misguided or unreasonable expectations were that evening when he turned himself in, do not apply any further.
The prosecutor went on to point out that Rittenhouse doesn't even live in the state. He lives in the neighboring state of Illinois, and that not only would he be a flight risk, but he doesn't have any close ties to the community there in Kenosha. Ultimately, the judge agreed with him.
Yeah, I think that's the strongest argument, that he's not from there. But Michael, do you think there's any weight given to the fact that you fight extradition as indication that you're a risk of flight?
You know, I was surprised that the judge said that, Vinny. I don't think there should be. I have a big problem with that because at the end of the day, it's a defendant exercising his rights. That is his right to challenge that extradition. Now, we all know it was basically just a fait accompli. It was going to happen anyway, but he has every right to do it. And the fact that they used that against him and the judge mentioned it, now I can certainly understand a prosecutor suggesting it, but to actually have used it when he was giving his order did really surprise me.
All right, Chanley, how about the defense?
Right, the defense attorney, Mark Richard, actually made an impassioned plea for a bail of $750,000 with conditions, of course, and his argument was all about this is a case of self-defense. Let's listen.
The criminal complaint is full of material omissions, whether through negligence or through recklessness. It doesn't talk about Mr. Rosenbaum chasing my client while masked, covering his identity. It doesn't talk about Mr. Zeminski, his partner, firing the first shot at my client. When my client is running down the road trying to get away, he goes and Mr. Groskowitz approaches him and goes, "Where are you going?" "Going to turn myself into the police," which he tried. It's on video. The self-defense claim in this case is overwhelming. It's on videotape. And under all of those circumstances, $750,000 and electronic monitoring is more than sufficient. We have no objection to the non-monetary conditions, but at a certain point, the state can bury their head in the sand. And in reality, who struck my client first? Who attacked my client first? Mr. Rosenbaum, the decedent. My client's running down towards the police line when he's attacked by a mob. We're not talking about demonstrators. We're talking about rioters who had ill intent in their heart, and unfortunately, they came in second.
His strong words didn't seem to resonate with the commissioner there, even though he argued that Rittenhouse wasn't a flight risk and that he even tried to immediately turn himself into authorities that night. It didn't go over.
You know, Michael, he talks about the videotape. You know, he's arguing the videotape shows everything you need to see. And one of the victim's fathers is saying, well, everything's on the videotape. That's all you need to see. That same videotape is being viewed through two different filters. And I think it may end up that way in a jury room.
Yeah, this is a tough one, Vinny. We had this argument on Friday. You were saying how you saw it. I said how I saw it or how someone else could see it. It's like a political Rorschach test, right? You throw it out there. Depending on which side you're on, that's what you're going to see on that tape. But, you know, as I listened to him speak, I thought maybe he crossed the line a little bit in terms of he's got to show some sympathy for the victims here, but he didn't show any at all. But he's doing what a good defense attorney should be doing. He's continuing to put facts out, or at least his version of the facts out, into the public ear, into the public eye. They've already did a beautifully produced video with their version of the facts, the way they think it went down. That's exactly what he's doing here. He's continuing to put out their facts that he wants the public to understand, what he wants the public to see with all the political background. Makes great sense, and he's doing a fairly good job of it.
All right, Chanley, how about the 17-year-old? Did he speak today?
He did speak from the video feed at the jail there with his orange mask and navy blue jumpsuit. He only responded to the commissioner's inquiries versus the dealing with the conditions of bail and the preliminary hearing. Let's listen to what he had to say.
All right, thank you. Mr. Rittenhouse, again, can you hear me clearly? This is the commissioner speaking.
Yes.
All right, thank you. Now, you have a right, sir, when you're held in custody in a felony case in the state of Wisconsin, to have a preliminary hearing held within 10 days of your initial appearance. Do you understand that?
Mm-hmm.
All right, but you also have the right, sir, to waive that time limit, allow this court and ask the court to toll time in order to schedule your preliminary hearing farther out or beyond that 10-day limit. Do you understand that as well, sir?
Yes, sir.
All right, that's what your attorney, Mr. Richards, indicates you wish to do. Do you understand that?
Yes.
Is that what, in fact, you do wish to do, sir?
Yes.
If Rittenhouse does make bail, he is supposed to have no contacts with the victims or the family of the victims and no weapons in his possession. The commissioner did set a preliminary hearing date, and that is for December 3rd at 11:30 a.m. Eastern.
All right, December 3rd, preliminary hearing. Michael, do you suspect that prosecutors will play all the videos that they have? Because we've seen and we have the video of the second incident, the second shooting, the second and third shooting, right? Because one of them survived there. The first shooting, haven't really seen any good video of that. I mean, it seems that that may exist. Do you suspect that we'll see it? And would prosecutors put it out there, or perhaps the defense?
Well, it does exist because we've actually seen some video. As I said, the defense has produced a slickly produced video that they put out themselves in an attempt to sort of get out in front of this story. And they had video, it was from a distance, and we were watching it, and we couldn't quite tell exactly what precipitated everything. So there's a lot there. It's hard to say, Vinny, because just from watching the snippets of video that we were able to see, you can't really tell what story is being told by the video. I suspect a good prosecutor is going to want to get that out in his own case rather than leave it up to the defense to bring out, and he's going to try to paint it in the way he wants the jury to see it. So I suspect anything that they find, they're going to put out and try to paint it in the way that they want it painted, as opposed to having the defense put it out, which then gives it a little more strength and power than you really want as a prosecutor.
All right, Michael Ayala, Chanley Painter. You know, what a great team. Every night, we bring in the best of the best, folks. All right, when we come back, Johnny Depp